So you've been charged with a criminal offence and have now engaged the services of an experienced criminal lawyer. Let's take a brief look at what you can expect from your first appointment and what documentation you will need to bring with you. Once you've been charged with a criminal offence, the police must provide you with a number of documents. These would include a copy of the prosecution notices, a copy of the statement of material facts, and a copy of your bail undertaking or court hearing notice. It's very important that you have a copy of these documents when you attend your first appointment. Without them, your lawyer won't know exactly what you've been charged with or the factual circumstances that have been alleged. The contents of the statement of material facts will also indicate whether the accused person participated in a police-recorded interview. This is something that your criminal lawyer will inevitably want to know when you attend your first appointment. After reading and considering the documents provided, your criminal lawyer will likely advise you on whether the alleged facts constitute the offence. You'll be advised of the meaning and content of the elements that make up your charge, and your lawyer will probably ask what you intend to do with your charges and whether you wish to plead guilty or not guilty. You may initially believe you are guilty of an offence, accepting the statement of material facts as being an accurate reflection of what occurred. For instance, if you were charged with assault, you may think you are guilty because you accept that you did in fact strike the victim as alleged. However, further inquiry by an experienced lawyer may reveal you have a defence to the charge due to provocation or having acted in self-defence. Conversely, you may believe your actions did not constitute the offence for which you have been charged, and after an objective assessment of the facts, your lawyer may reveal the prosecution case against you is in fact strong. If you participated in a police-recorded interview, your lawyer will want to view and consider that interview before advising whether you have a defence to your charge. At your first appointment, your lawyer may advise you on which court your matter will be ultimately determined in. In Western Australia, criminal offences are made up of simple and indictable offences. Regardless of whether you are charged with a simple offence or an indictable offence, all prosecutions are commenced in the Magistrates' Court. Generally speaking, simple offences are less serious than indictable offences, which are typically determined in the District or Supreme Courts. The Magistrates' Court cannot impose the lengthy terms of imprisonment that are commonly imposed in the District and Supreme Court. However, offences that are dealt in the Magistrates' Court can and often do attract terms of imprisonment. If you've been charged with a criminal offence and want to ensure your interests are being looked after by an experienced criminal lawyer, contact Andrew Williams Criminal Law Officers on 08 9278 2575 to arrange an appointment time.